Good afternoon, everyone. My name is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru Tumarkin, the Western Canada Employment Practice Leader. I'm joining you here from Calgary today, rainy Calgary. We're here today to get as many of your employment law questions answered as possible in the next 25, 30 minutes. Anything you have that's on your mind related to your employment rights, I'm here to do my best to give you the straight answer, the straight goods on what the law says about your situation. So if you have any questions related to your job, put them in the chat. We're going to get through as many of them as possible. One thing I wanted to discuss, it always kind of comes up at this time of year as we get into the summer months, is for those of you who work outside, or maybe you work inside, but it's not air conditioned, what are your rights when it gets hot, when it gets really hot? I'm not just talking about a little heat, but when it gets really hot. What are your rights? Do you have to continue to work, especially if it's a physical job, if you're in construction? I know people that work in a very hot kitchen sometimes, especially during the summer months. That kitchen gets really hot. What are your What are your rights? All right. So everyone in Alberta, BC, and Ontario have the right to work in safe working conditions, and that includes being safe and protected from heat strokes and things of that nature. So generally, that right encompasses your right to a safe work environment and to refuse unsafe work. All right. So if you are feeling that you are being asked to do a job that is unsafe because of the heat, because the chance of a heat exposure, heat strokes, dehydration, anything like that, you can refuse to do that job. All right. And without penalty, without fear of retaliation, without fear of losing your job or anything like that. All right. So basically what you would do is you would tell whoever your supervisor is, I cannot do this job. I don't think it's safe. Once you do that, you trigger a process. Okay, a process needs to then unfold to find out if whether your unsafe work complaint is legitimate or not. All right. The first step the supervisor has to do is decide whether he or she thinks the work is unsafe as well. They oftentimes are required to involve the health and safety committee. And if they agree that the work is unsafe, then you won't be required to perform that work, or they'll find a way to make it safer. All right, that might be providing frequent water breaks, shade breaks, whatever it is. You then determine whether these accommodations for the safety of the job, whether you think they're sufficient. All right, and if you do, you can go back to work with these new accommodations for the heat risk. If you don't, you continue to maintain that this is unsafe work. You're refusing to do it because it's unsafe. If the employer disagrees with you and says, no, this work is safe now, so you do have to do it, and there's a disagreement between the two of you, it's not that the employer is right and you're wrong. Instead, what needs to happen is the Ministry of Labor needs to be brought into the mix, okay? So the employer's job is then to contact the Ministry of Labor saying there's a work refusal due to unsafe work in the workplace. The Ministry of Labor will send an inspector to review the workplace and whether it's a safe work environment. And once the inspector makes their determination, then that's what needs to be followed, okay? Some people say, I can't risk that. I mean, it's a precarious job that I have, all of that. If an employer retaliates against you for having brought an unsafe workplace, an unsafe work complaint, you have a lot of rights, all right? So you have the right to be free from retaliation, free from reprisal. The Ministry of Labor will enforce your right to be free from reprisal. If you get terminated, they can force your employer to take you back into the job and pay you back wages for any time that you were terminated or unemployed due to the termination. So you have a lot of rights. So I don't want any Albertan or BC or Ontario workers going out there doing unsafe work because the job is so important they can't afford to lose it. You won't lose it. You can go ahead and raise your hand and say this is unsafe. All right. And that applies, of course, for heat strokes, for heat hazards, for cold hazards in the winter if it's really, really cold, and any hazard generally. All right. If you feel that the work you're being asked to perform is unsafe, raise your hand. I'm refusing to do this. This is unsafe work. That's the first step. So remember that. All right. In the meantime, we had some questions come in from the audience. I'm going to get to those now. We have a first question coming in from YouTube from Helen Webster. She's asking, I was told in my hiring process that I would be on probation, but there is nothing in my contract that states this. Is it enough for them to only mention it verbally? So a contract can be verbal, and yes, you can be put on probation for verbally. The problem with verbal contracts is always, proving its terms when there's a disagreement between the parties. Here, you seem to be indicating that you agree you were told you would be on probation, so there's no real dispute that you were told that was a contractual term that you accepted when you accepted the job. So now you're on probation. I don't know if they told you how long the probation was supposed to be, and that's the problem we start getting when we look at verbal contracts. The first, you'll be on probation when you start doesn't really tell us much. When does the probation end? How long does it last for? No one knows this, right? So if they terminate you in a year because they're saying you were on probation, did you know you were going to be on probation for a year, right? So that's the problem with verbal contracts. But if the parties agree to the terms of the verbal contract and agree that the verbal contract was this, then yes, a verbal contract can be legally enforceable. Yes, it can be. So keep that in mind. That said, you have rights. Despite any verbal or written contract, you have rights under certain employment standards legislation, which means that if you've been employed for over 3 months, whether or not you're still on probation, because the probation can last more than 3 months, you would still be entitled to certain compensation if you're terminated under employment standards legislation. All right. So I don't know if this is a hypothetical question for you, Helen, or if you have been terminated and the employer is claiming that you were on probation. If it's the latter, something specific has happened, please reach out to us. We'll be happy to discuss with you what your options are moving forward. If you're looking to reach out to us, it's very easy to do so. You have the website on the screen here, employmentlawyer.ca. All right, just reach out to us, employmentlawyer.ca. We'll be happy to speak with you. We have another question coming in from Aura. Aura is asking, on point to what I was just stating at the start of the show. I work outdoors and we've had a lot of smoke advisories lately. Can my employer force me to work outside if the air quality is dangerous? Again, this is precisely so I am not an expert on air quality by any means, but I see it on my phone when we have a smoky day here in Calgary that, it's recommending that, at some point it's recommending that no one do strenuous work outside. And I would basically follow that advice. If I was asked to do strenuous work outside, I was raise my hand and say, this is not the day for it. Right? This is not the day for me to be, putting in, concrete sidewalks or digging trenches or anything like that, right? I would raise my hand and say, listen, let's take this day off and come back when the air advisory has dissipated. Your employer might say, well, actually, we've asked our health and safety expert, and they say that, it's safe to do so if you're able-bodied, so long as it's, the PPI, or whatever they use is of X amount. Or they might say, well, I'm going to give you an air mask that you can use that'll filter out the smoke particles or something like that. And then you decide, is that enough for me to work safely? I don't know, how comfortable I personally would be with a face mask if I'm doing strenuous work and, need to breathe heavily and stuff like that. I don't know if the face mask would work well for me in such a situation. I don't know. I've never tried it. But that's something that you would try and figure out. And if it's still not working for you at that point, or then it's to say, no, this is not working. I don't think this is safe. We need to call in the Ministry of Labor. Ministry of Labor does have the experts on air quality, on heat strokes, and all of that. And they can tell you to what extent it's safe. And obviously, at some point, it becomes unsafe, right? And I'm not talking about those that are fighting the wildfires. They have their own kind of procedures. But if you're just a regular person doing a regular job, building houses and construction or things like that, you're not dealing with any emergencies. You're doing a regular job, and you should be doing it in regular, safe circumstances. I hope that answers your question, Aura, because that is another concern for sure. Not only is it the heat, but sometimes, unfortunately, it's also the smoke coming in from some of these wildfires we have happening right now in certain parts of Canada. We have another question coming in from YouTube from user AO4618 asking, what is the difference between severance and notice? Great question. Basically, severance is kind of the colloquial, the everyday word we use, and notice of termination is the legal term. All right, so they basically mean the same thing. Okay, so if you are being offered 6 months of severance, you're being offered 6 months of notice of termination. The complicating factor, AO4618, is if you're in Ontario, severance has a second meaning under a law called the Employment Standards Act. All right, so severance is a compensation that you get for if you're terminated and you have over 5 years of service. Not only do you get termination pay, but you get severance pay. It's not the same amount. It's not the same thing as the severance that's called notice of termination, and so it confuses everyone. And I'm not sure exactly why the government chose severance as the term, because it just confuses the situation that's already quite confusing. Because you have certain rights under the Employment Standards Act, and you have certain rights at common law in the general civil law of the civil courts. All right. And at common law, your severance entitlements or your notice of termination entitlements can be quite substantial, up to 2 years of severance, whereas under employment standards legislation, they're capped. All right, you can get up to 8 weeks of termination pay in Ontario and up to 6 months of severance pay in Ontario, for a total of 34 weeks total. Whereas in the civil court, without looking at employment standards, you can get up to 104 weeks or 2 years of severance, and sometimes a little bit more in certain special circumstances. So all very confusing. But if you're looking at something that's about 1 or 2 years, weeks per year of service, it's probably you're being offered what you're owed under employment standards, but not your full entitlement. So it's very important you get those checked out and figure out how much you're actually owed. And if you're wondering if what you've been offered is a good deal, very easy to do that. You can just go and check on our severance pay calculator. We've created that to allow people to understand what they'd be entitled through the civil law system, through the common law system that we use. And if you're looking to find out how to get that, go to pocketemploymentlawyer.ca. And if you go to pocketemploymentlawyer.ca, you'll have an opportunity to answer just 4 very easy questions. And we'll give you an estimate in dollars and an amount of months of how much severance you might be entitled to if you're terminated or if you've been terminated. And like that, you have an idea of whether what you've been offered is a good deal or not, or whether you're entitled to significantly more. So once you've got that information, give us a call. We're happy to explain to you how we get from point A to point B, which is what we come in and when we come in and help you get what you're entitled to. All right. So that's the kind of long-winded answer to severance and notice. So the real difference is between employment standards and common law. All right. All right. So we have another question coming in from Lily Stapleton. Lily is asking, if I have to take a sick leave before I start maternity, can my employer take issue with this and let me go? So Lily, no. Basically, if you are required to take a sick leave, it's going to be because your doctor is putting you on sick leave, right? So you wouldn't just unilaterally decide that you need sick leave. You would get a doctor to recommend that. And once that happens, you are on a job protected leave, both under employment standards and under human rights legislation. You'd be on a job protected leave. Okay. So if can your employer let you go? Anything's possible, but they would be in a lot of trouble if they did. Okay. So you have the right to return after a medical leave and after a maternity leave to the job you had prior to your termination. And you definitely have the right to be protected from termination, discriminatory termination, because you've taken a sick leave or because you've taken a maternity leave. So if either of those things have happened to you, or you fear that those things might happen to you, reach out to us. Don't wait till it's happened. Reach out to us so that we can advise you on the best steps to navigate these troubled waters, so that you end up with the best result, the best outcome possible for yourself. All right. And if you're looking to reach us, you have the website on the screen there. It's employmentlawyer.ca. Employmentlawyer.ca. We have another question coming in from YouTube from Jonah. Jonah is asking, I work as a site supervisor. After 15 years, the site is shutting down. I've been informed that at the end of July, I'll no longer have a job. I have not been offered severance. Am I owed anything? It's a construction industry job. Okay. So you didn't mention which province you're in, but assuming you're either in BC, Alberta, or Ontario, Jonah, under the employment standards legislation in those three provinces, you are entitled to a certain minimal amounts of termination pay if you're terminated. Okay. Some categories of employees are exempt from those minimum entitlements, and construction workers are part of those exemptions. So if you're terminated from a construction job, your employer doesn't have to pay you certain minimum termination entitlements under employment standards. But as you heard me discussing earlier, you have rights to compensation upon termination from two sources generally in BC, Alberta, and Ontario. And you have a right to compensation through employment standards, and you have right to compensation through the common law, through the civil courts. All right. And construction employees are not exempted from getting their common law and civil court entitlements to severance pay. So yes, all this to say, Jonah, you are entitled to severance. Okay. What I would recommend that you do is contact us at employmentlawyer.ca so that we can help you get the severance you're owed when you're terminated at the end of July. Okay. So if you're looking to see how much you might be entitled to, so employmentlawyer.ca is how you reach us. You can also reach us from our severance pay calculator if you're interested in speaking with us. After you've determined how much severance entitlements you might have, you go to pocketemploymentlawyer.ca, severancepaycalculator.com, and you can calculate how much severance you might be owed. And once you see that number, if you're interested, if you think that number is worth pursuing, reach out to us. We'll be happy to speak with you and let you know what your severance entitlements might be. As a rule of thumb, I can tell you, you may be entitled to up to 2 years of severance. So definitely in your case, you might be looking at least at over a year of severance that you might be owed, Jonah. So definitely think about it. It could be a very substantial sum of money that you might be entitled to. Okay. And we have time. We have to do a little bit of a shorter show today, unfortunately, those of you who are tuned in. So I'll take two last questions here. We have a follow-up question from Lily Stapleton, who was discussing taking a medical leave prior to a maternity leave, and is following up, or what if I have to go on sick leave after maternity leave ends? I've got a few health problems that my doctor is not sure how they will progress, so I'm worried. So Lily, no matter when you take a sick leave, if it's doctor approved, you have rights to a job protected leave under both employment standards and human rights legislation. All right. That's the short answer. So long as your doctor is telling you and your employer that you need time off to take care of your disability, then it's your doctor you need to listen to. And if your employer is saying, well, listen, we don't agree with your doctor, we don't care what your doctor's saying, if you don't come to work, we're going to terminate you, contact us. Don't wait till it happens. Contact us beforehand so we can help you navigate, like I said, these troubled waters, get you to the best potential outcome. All right. So if after you've submitted a doctor's note requesting some time off, they are still saying you can't have the time off, reach out to us, employmentlawyer.ca. You have the website right there on the screen. That's how you get in touch with us. All right. And our last question for today is coming from YouTube, from Cora J. Cora J is asking, I work for a small business owner who is verbally abusive and very difficult to work with. Is there any way that I can leave this job and receive EI? It's affecting my mental health, and I just can't continue. So not only may you receive EI, but you might also be entitled to severance. What I often see, though, Cora, is people come and tell me, my boss is verbally abusive, and I asked the boss about it, and they say, absolutely not. I'm not verbally abusive. I'm a nice person, right? So we have to, you want to basically be able to establish that this is not a he said, she said situation, but rather have some documentary proof of it. So I've seen some people record these outbursts. I've seen people simply write an email to the boss saying, "Listen, the way you spoke to me yesterday, where you said X, X, and X, is inappropriate, and I felt verbally abused, and I'd like you to stop." And even if your boss doesn't even respond to that, well, just the fact that they don't even respond is, in a way, a sort of acknowledgement that it happened. All right, and if they do respond, then we have their version of events, and you have a better idea of what are going to be the difficulties you have in proving this. But if you quit, there's such a thing in EI of quitting for cause. So you quit for cause is the same as quitting due to a constructive dismissal. It means that you were kind of forced to quit by the employer's actions, and therefore that entitles you to EI. So what you would typically do is quit, apply for EI. EI is going to call you up saying, "What gives? It says here you quit, but you're applying for EI. Why?" And you explain your story. They'll investigate, and if they agree with you that you had no choice but to quit, they'll allow you to access EI. Not only that, you should contact us, because you may also be entitled to severance if you were forced to quit by your employer's behavior. All right. And if you're looking to reach out to us, it's right there on the screen once again, employmentlawyer.ca. All right. Thank you all for joining me for this abbreviated version of our show. I tried to speak a little faster than usual to get as much information in. My name is Lluc Cerda. I'm the employment practice leader for Western Canada. I am the managing partner of the Calgary office of Sanfiu Tumarkin. I just want to close off with Nero's note. This is really great information. Everyone should pay attention. Thank you, Nero, for your kind words. And Brianna saying thank you as well. Thanks for joining, Brianna, and thanks for listening in. Our next show is tomorrow. So if I didn't get to all your questions, feel free to ask them tomorrow. My colleague Sefton Liebrandt is going to be running the show from 1 p.m. Eastern. Tomorrow, log in, join, tune in, and we'll be happy to get to a lot more of your questions. So keep them coming. Thank you very much, and have a good day.